Welcome, welcome, welcome. Welcome, everybody. Today is Judge Lynisse Bryant. And yes, I'm still working on a new YouTube channel. So please be patient with me as I'm trying to get these things done. So let's get this started with Judge Lynisse Bryant.
All right, I am ready. Mr. Flanagan,
Yes, Your Honor.
while I'm finishing up setting up the live stream, can you please bring in Mr. Matthews for me?
Yes.
Thank you. Mr. Matthews, please start your camera. Thank you. All right, I am ready on Matthews. Give me one moment. All right. This is case number 224526101, the people of the state of Michigan versus DeLon Tajay Matthews. The defendant is charged with one count of operating while intoxicated, and today is the date set for a pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Renner on behalf of the people of number 83505.
And good morning, Your Honor. May it please the court, Lowell Friedman, P56185. Your Honor, I appear this morning by Zoom with approval and consent along with my client, DeLon Matthews.
And Mr. Matthew, I apologize. Counsel, did you say your P number? I'm sorry.
I did. I'll repeat, 56185.
Oh, but you did. Okay. I just didn't remember hearing it. All right. And then Mr. Matthews, please state your name for the court. Unmute for me, Mr. Matthews. Oh, you're not muted.
It was faint.
All right. State your name again for the court.
Hello, you hear me?
I do, sir. State your name for the court. Yeah, he's freezing up. Stop.
Say your name, DeLon.
DeLon Matthews.
And what's your middle name, sir?
Tajay.
Thank you. Matthews, I need you to be stationary. I need you to be stationary, meaning no moving. Today is the date set for a pretrial conference. How are we proceeding, Mr. Friedman?
Your Honor, I'd like an opportunity to speak with Ms. Ritter to see if we can resolve this by way of a plea. I'm in receipt of the discovery, the tender discovery, as well as the video. I'm hoping that we can resolve this by way of a plea bargain.
And so today, that means you're going to continue your client's not guilty plea?
Yes, Your Honor, unless there's any way that I could meet with Ms. Ritter to see if we can resolve this matter today.
No, that's what we do before we come to court. We call the prosecutor and y'all work it out before we come to court. Ms. Ritter is in person in the courtroom. She's not available to go to a breakout room.
Okay, Your Honor, I understand. I'll reach out to her today.
All right, then the court will continue a not guilty plea on behalf of Mr. Matthews, and I will set the matter for a final pretrial conference. And I believe I am available for that on October the 2nd, I think. Mr. Flanagan, am I available on October 2nd? How many do I have?
If I may, Your Honor, I'm in court at 9:30. I will be available by Zoom if it's 8:25 again. That would be great for me.
It's going to be 9 o'clock, but it is on Zoom.
Okay, Your Honor, I'll handle it from the parking lot.
All right, Mr. Flanagan, am I available October 2nd?
Yes, Your Honor. 28 on that day.
So this makes 29. That means I only have space for one more potentially. All right, the court is gonna set the matter for Monday, October the 2nd for a final pretrial conference at 9:00 a.m. on Zoom. Bond will continue with no drinking, no driving without a valid license. Anything further?
No, thank you, Judge.
Nothing from defense, Your Honor.
All right, then we're all set, Mr. Matthews, until October 2nd. Have a great day. Stay safe.
Thanks, Judge. Have a great day.
All right, you're welcome. Thanks.
Bye-bye.
Bye-bye. All right, I'm ready on Sanchez Guzman. And this is case number. Whoa, okay. This is case number 214537701, the people of the state of Michigan versus Raul Sanchez Guzman. The defendant is charged with one count of assault or assault and battery. Today is the date set for a final pretrial conference. Appearances, please.
Morning, Your Honor. Alan Cooper for the
Hold on,
defendant.
counsel, the people first.
Oh, I'm sorry.
For the record, Your Honor, Christina Ritter on behalf of the people.
All right, now counsel.
I'm sorry, Judge. Alan Cooper for the defendant,
And your P number?
49819.
And Mr. Sanchez Guzman, please unmute yourself and tell the court your name.
Raul Sanchez Guzman.
Thank you, sir. Today is the date set for a final pretrial conference. Mr. Cooper, how are we proceeding?
We would ask for a jury trial to be scheduled.
Court is going to continue a not guilty plea on behalf of Mr. Sanchez Guzman, and I will place this matter on the jury trial track. Mr. Sanchez Guzman, there are approximately 40 cases in front of you for a jury trial. I am waiting for a jury trial date. I'm going to set this matter for a final pretrial conference. Oh, did I leave my other calendar? Give me 1 second. Monday, March 4th, 2024 at 9:19.
9:19 in the morning.
Yes,
Judge, may I request a Spanish language interpreter be available for Mr. Sanchez Guzman?
oh, well, did he need one today?
I think since we're simply just scheduling a new date, I think that it's fine. He can understand some things, but I think that it might be best for future proceedings if we have a Spanish language interpreter.
Oh, all right. I wish I'd known that today. Mr. Sanchez Guzman, did you understand that I'm adjourning the case?
Yes, today, yes.
Okay, thank you. Yes, okay. Then the court sets the matter for March. What did I say? I'm sorry. March
It said March 4th, actually.
yes, March 4th at 9:19, and that just lets me know that there's a jury trial schedule, needing to be scheduled. And yes, we will order a Spanish interpreter, you said?
Yes, Judge.
All right. We
And
will
then
have a Spanish interpreter.
Thinking that court date on March 4th is a final pretrial date. Is that
Final
correct?
pretrial, and I will give you your jury trial date at that time.
Okay.
Hopefully, I'll be able to give it to you. It'll be like the fall. They are supposed to be making some adjustments to my docket, so that may change, and I may be able to give you something earlier, but right now, that's what it is.
Great.
All right? Then
Thank you,
we're all
Judge.
set. You're welcome. Have a great day. Stay safe.
You too.
Thank you, Your Honor.
Thank you. You're welcome.
You have a nice day. Thank you very much.
Thank you. All right, Ms. Ritter, you can go ahead and go and talk to your witness.
Okay, Judge.
All right, Ms. Arnold, good morning. I am going to send you to a breakout room to speak with the lawyer. Please remain in the breakout room until a lawyer has come in to speak with you. Do not leave the breakout room until you have spoken with the lawyer, okay?
Yes.
I hope you're not getting dressed, Mr. Polk. I hope you're not. I just hope you're not. I hope you're not getting dressed. I hope you're already dressed for court. Oh, wait, what did I just do? Miss Arnold, why I don't see you on the, oh, there it is. Oh. Oh, thank you. Okay. Let me bring her. That's a mess and I'm just gonna delete him. All right, let me bring her out. Miss Arnold, I apologize. You already have a lawyer. So I'm going to put you in the waiting room and we'll call your lawyer. Okay. All right. Well, first let me change your name. All right. Mr. Polk, don't ever come to court again. And well, first of all, you on the bus, and I'm not going to have court with Mr. Polk on the bus. And then no. And then he got to put his ear up to the phone because he can't hear us because he's on the bus. And I'm trying to figure out why was he outside getting on the bus with his shirt off, logging into court with his shirt off. It was very rude and it was very disrespectful.
If you can let me,
I'm not going to have court with Mr. Polk on the bus. So, Ms. Stevenson, I don't know where he's on his way to, but I'll put him in a breakout room. But let's be clear, I won't have court with Mr. Polk on the bus. I will not have court with Mr. Polk on the bus. He's not listening. He's doing a whole bunch of stuff. He's not even looking at his screen. I mean, it's just so distracting. I can't imagine. So if you would please look at your screen and accept to join a breakout room. Don't have no attitude with me. Don't have attitude with me, because if you have attitude with me, it's just not going to work out for you, but it's going to work out for me. Ms. Stevenson, you might need to go in and talk to Mr. Poe, because I don't know where he's on his way to on the bus, and he's supposed to be in court.
Yes, Your Honor. Shall I go now, Your Honor?
Well, he's still on the screen, so I don't know.
I'm
Mr. Pope, join your breakout room, please, sir.
I removed him. He didn't go to the breakout. I removed him. Are we ready on Williams Ross? No, I mean, ma'am, what are you doing?
Are you
This
asking
is
me?
ridiculous. No. This is, now, let me say something to you. I don't know who met with Miss Williams Ross in the breakout room, and I don't know what instructions were given in the breakout room. But ma'am, if you sleepy, don't log on to court. If you're gonna go to sleep while you waiting, don't log on to court. If we have to bring you out of the room and see your thigh, don't log on to court. I'm just telling you, this is unacceptable. You need to be sitting upright. Sitting upright in an upright, it's not a conversation. This is not a conversation we're having. This is not a conversation we're having. And I'm gonna send her back to the breakout room because it's not gonna work out well for Miss Williams Ross this morning. I'm gonna send her back to the breakout room because she's confused and she's lacking understanding on the proper way to come to court on Zoom. So we're gonna send her back to the breakout. Stop doing that. Put your hands down. Put your hands down, ma'am. She's gonna go to breakout room number 5, and Miss Stevenson, you're gonna go in breakout room number 5 with Miss Williams Ross.
Yes, Your Honor.
Miss Blackwell, I'm gonna put you back in the waiting room and I'll bring you back out shortly. Miss Rodman, were you the intern that spoke with Miss Williams Ross?
Yes, ma'am.
I'm gonna send you to the number 5 with them.
Okay.
Ms. Stevenson didn't come back out. All right, Mr. Murad, are you already on something? Oh, never mind, just hold tight. Ms. Jefferson is here. I'm gonna handle her case and then I'll be ready again for MFD. Good morning, Ms. Jefferson. Good morning.
Good morning.
Good morning. Are you ready on, Ms. Arnold?
Yeah, I need to speak to the prosecutor.
It's not possible, Ms. Jefferson. You got it. Of course, she's in the courtroom. She's not on Zoom. We have a trial starting in a minute.
Some reasonable efforts towards the permanency goal to adopt the recommendation.
Okay.
And I think it may be appropriate.
Let me look at, I believe I got it in my notes. I think I know there's an offer. And
schedule something.
my client and I have had many discussions
so that
and
we can get the report back from.
Okay. Well, all right. Okay, I'm ready on Williams Ross. Okay, this is case number 234465501. The people of the state of Michigan versus Fatima. Middle name starts with an N, last name Williams Ross. Defendant is charged with 1 count of assault or assault and battery. And today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Renner on behalf of the people, and the complainant witness is present on Zoom this morning. Ms. Blackwell, unmute yourself and just state your name for the court.
Kennedy Blackwell.
Okay, next.
Good morning, Your Honor. My name is Elisa Rahman, and I'm a second-year student in good standing at Detroit Mercy Law and request permission.
We're gonna stop. Ms. Stevenson, what's wrong with her presentation to the court?
She's sorry.
Somebody set her up for failure today.
Ms. Rockman is trying to make, she has a lot of moving parts, Your Honor. Ms. Rockman is actually a student in good standing at a law school accredited in the state of Michigan. And we would move that the court grant her permission to practice pursuant to Michigan Court Rule 8.120B, I think it is, under the supervision of myself and Mr. Murad.
That's a shame. That's a shame that I would stop her in the middle of her sentence because she was trying to say some other law school besides Wayne State. That's a shame that I would do that. Shame on me, but I'm gonna do it next time too. All right, permission granted.
Thank you, Your Honor. Elisa Rahman appearing on behalf of Ms. Williams Ross. Ms. Williams Ross, can you please state your full name for the record and also consent to me appearing on your behalf?
Fatima Nadia Williams Ross, and yes.
All right, today is the date set for pretrial conference. Ms. Rahman, how are you proceeding today?
Your Honor, we are asking for a final pretrial conference with the request for discovery, please.
Court is going to continue a not guilty plea on behalf of Ms. Williams Ross, and I will set this matter for a final pretrial conference. Mr. Flanagan, how many do I have on November 6th, please? Oh, no, I don't mean it. What's today's date? I'm sorry. 11. How many? Oh, I'm not here on the 13th. How many do I have on November 14th, please?
6.
Thank you. Court is going to set the matter for a final pretrial conference, November the 14th. At 9:00 a.m., discovery should be submitted to the defense by October the 13th. Bond will continue with no contact with the complaining witness. Ms. Blackwell, you have appeared today, and therefore, ma'am, you are not required to appear on November 14th. However, as the complaining witness, you may appear at all scheduled court appearances, but you are not required to appear on November 14th. If you do not appear on November 14th, you should contact the prosecutor's office to find out when the next court appearance is and whether your appearance is required. Anything further with respect to Ms. Williams-Ross?
No, thank you, Judge.
No, Your Honor.
All right, then we're all set until November 14th at 9 a.m. on Zoom. Ladies, have a great day and stay safe.
Your Honor, could Ms. Williams-Ross go back to breakout room for her interview, please, with Ms. Rahman?
All right, yes.
Thank you.
All right, Ms. Blackwell, you're all set, ma'am. And I will move Ms. Williams-Ross to breakout room number 1, as well as Ms. Rahman.
Thank you, Your Honor.
You're welcome. Ms. Jefferson, are you ready?
Your Honor, I'm sorry. I do need to speak to the prosecutor. I thought I had to, so I can once again relate to my client what the offer is. I believe I know what it is, but I'm.
Ms. Ritter, what's the offer on this case?
Planning hearing will be on the
And
21st.
Ms. Jefferson, you're gonna have to lower the volume on your other device.
I intend to make to
Very hard for me
if
to
any
hear.
party disagrees, you have 7 days to seek review after.
I'm sorry.
That's okay. What's the offer, Ms. Ritter?
Impaired, Your Honor.
That's the offer. Did you want
That's
to
what I
speak to the
thought.
client in a breakout room?
Yes, please.
And then, Ms. Ritter, are we ready? I'm not Ms. Ritter, I'm sorry. Are we ready? We're ready on Cohill and Nelson, correct?
Correct, Your Honor.
All right, Ms. Arnold, I'm going to send you to a breakout room number 10. It should pop up on your screen and your lawyer will come in to speak with you. All right.
Thank you, Judge. Thank you
You're
so much.
welcome. All right, I'm ready on Cohill and then Nelson. Cohill is having trouble coming in. Oh, there we go. Okay. All right, this is case number 164564201. The people of the state of Michigan versus Alexis Renee Cohill. The defendant is charged with 1 count of malicious destruction of property. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. My name is Daniel Galley. I'm a 3rd-year student in good standing at the University of Detroit Mercy School of Law.
Oh, pop. Ms. Stevenson, in a minute, I'm getting ready to say no. I'm going to say no. If these students going to keep trying to go rogue and put their school on my record, it's no schools on the record.
Sorry, Your Honor. I'm a 3rd-year student in good standing at an accredited law school.
Oh, yes, it is accredited. It is an accredited law school.
And I request permission to practice pursuant to Michigan Court Rule 8.120B under the supervision of Attorney Dennis Stevenson and Mr. Raid Murad.
Ms. Cohill, you almost didn't have a lawyer just now. I'm just playing with you, Ms. Cohill. Ms. Stevenson would have stepped in. She would have stepped in. All right. Permission granted.
Thank you, Your Honor. And for the record, is Daniel Galley appearing on behalf of Ms. Cohill, who consents to my appearance on her behalf. Is that correct, Ms. Cohill?
Yes.
And state your name, Ms. Cohill.
Alexis Cohill.
What's your middle name, ma'am?
Renee.
Thank you. Now, Mr. Lipper, if you try it, I'm gonna say no. You better practice your speech right now. Okay, Ms. Cohill, I apologize. I am exercising a little bit of levity this morning. Please forgive me. But laughter is sometimes good for the soul. She like, don't laugh on my case, Judge. All right, today is the date set for a pretrial conference. Mr. Now, see, I didn't even pay attention to your how to pronounce your last name because I was so focused on you saying this other law school on my record. How do you pronounce your last name, counsel?
It's Galley.
Galley, okay. Mr. Galley, how are you proceeding?
Today, Your Honor, we move for dismissal for the complaining witness failure to appear today.
Ms. Ritter?
So this case was arraigned by Your Honor, and the court scheduled this pretrial conference requiring the complaining witness, Ms. Doretha Cohill, to be present. I don't see Ms. Doretha Cohill in the waiting room, Judge, and I don't have an explanation as to why Ms. Doretha Cohill is not present. So at this time, Your Honor, the people will not be able to proceed based upon the complaining witness's failure to appear for today's pretrial.
Today is the day set for pretrial conference, and even though it sounds like this shouldn't be my case, the complaining witness was required to appear. They have failed to appear, and the people have no explanation for that failure. They are unable to proceed. The court is going to grant defense counsel's motion for dismissal and dismiss the matter without prejudice. Ms. Cohill, the court will mail you a copy of the order of dismissal for your records, okay?
Okay.
Have a great day and stay safe.
Thank you. You as well.
Thank you. All right, I'm ready on Nelson. Looks like we could have started the trial at 10 o'clock. Sometimes. Let's see, if I had said that, then we would be going until, yes. All right, I'm ready on Nelson, and this is case number 234464901, the people of the state of Michigan versus John Andrew Nelson. The defendant is charged with 1 count of retail fraud. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. My name is Matthew Lippa, and I am a third-year student in good standing at an accredited law school and request permission to practice pursuant to Michigan Court Rule 8.120B under the supervision of the attorneys of misdemeanor felony defenders.
Perfect speech.
Thank you.
Permission granted.
Matthew Lippa appearing on behalf of John Nelson, who consents to my appearance on his behalf today. Is that correct, Mr. Nelson?
Unmute Mr. Nelson, please.
Yes, I consent.
And state your name, please.
John Andrew Nelson.
Thank you. Today is the day set for pretrial conference. Mr. Lippa, how are we proceeding?
We move for dismissal today, Your Honor, as the complaining witness has failed to appear.
Ms. Ritter.
Judge, the corporate complaining witness, Home Depot, does not have a representative in the waiting room, and the people have no explanation as to why our representative on behalf of Home Depot is not present. So at this time, Your Honor, the people will not be able to proceed based on the corporate complaining witness's failure to appear for today's pretrial conference.
And this is the second scheduling, so I'm assuming that means that Home Depot did not appear at the first scheduling?
That is correct, Your Honor.
Today is the day set for pretrial conference. The complaining witness was required to appear. They have failed to appear. The people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion and the matter is dismissed without prejudice. Mr. Nelson, we will mail you a copy of the order of dismissal for your record, sir. Have a great day and stay safe.
You too, thank you.
You're welcome. Oh, wait, I brought Miss Arnold back in, but what happened to Miss Jefferson? Oh, Miss Jefferson's still in the breakout room. Okay, why is Miss Jefferson? Okay, Miss Arnold, give us a moment. I thought your lawyer was on screen, but maybe she was on 2 hearings. So I'll bring you right back out when she comes out of that breakout room, okay? Let's try to bring in Mr. Polk again. Maybe he's reached his destination, but maybe not. No, he has not. I mean, just a complete mess. Just a mess. Ms. Stevenson, okay. Can't even. All right. Don't know about Ms. Jefferson, but we'll be on recess until Ms. Jefferson comes back or Ms. Stevenson gets Mr. Polk stationary and ready to attend court. Oh, let me check my email. Mr. Flanagan,
Yes, Your Honor.
can you please call Mr. Torres and let him know that I sent an email this morning? And if someone would please respond to my email regarding Shavante Jackson.
Yes, ma'am.
Thank you. You ready? You early, counsel, you early. Yes, you ready? You ready?
I put a tie on for you.
All right, but I'm glad to see you because that made me think about getting the chairs ready for the trial.
Can I help move anything?
Oh no, we don't have any money to pay on the deductible if you hurt your back. Officer, who is my officer? Officer Crafts?
Yes, Your Honor.
I need 3 counsel chairs and 3 defense chairs for the defendant's side of the table, please.
Yes, Your Honor.
You all can take that chair from the jury box, jury seat number 8. And then we might have to get my chair out of the hallway, but I probably might need my hallway chair. So you might have to contact procurement. But we need 3 and 3. 3 and 3. All right, I was just saying that it looks like I'm gonna finish my morning docket early, and wouldn't it be nice if I could have started my trial earlier?
Well, you know, it's always a pleasure to be here, and when everybody comes, I'll check in with Ms. Ritter.
All right, I'll be downstairs after I finish these last couple of cases. All right. Day set for pretrial conference. How are we proceeding?
On behalf of Mr. Polk, we thank the court for hearing this matter. Mr. Polk will, on his behalf, we move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Your Honor, it's at least the second scheduling of the pretrial conference, and the court requires the complainant witnesses, Mr. Tashawn Brown and Ms. Asia Taylor, to be present for today's hearing. I don't see neither of the complainant witnesses in the waiting room, nor do I have an explanation as to why the complainant witnesses are not present. At this time, Your Honor, the people will not be able to proceed based on the complainant witnesses' failure to appear for at least the second scheduling of the pretrial conference.
Today is the day set for pretrial conference. The complaining witnesses were required to appear. They have failed to appear, and the people have no explanation for the failure. The court is going to grant this. The court is, in a minute, I'm going to say Mr. Polk just got to come in person.
Be still, Mr. Polk.
Oh.
Be still, like a picture.
I mean, he's doing so much. It's just been a struggle having court with you this morning, Mr. Polk. You came on showing us your bare chest. We didn't want to see it, but you showed it. You showed it.
And
to
I apologize.
Quiet, Mr. Polk. Just be
Oh.
quiet and listen.
Because you apologizing for showing us your bare chest is of no consequence. There should not have had to be an apology because we're in court. And who would come to court with their bare chest? Who would do that? No one should. And then I had to deal with you being on the bus. And you're acting as if you're doing me some type of favor. But you're not. You're not doing me any favor. This is your court date. The complaining witnesses were required to appear. They have failed to appear. The people have no explanation for the failure to appear. They are unable to proceed. The court is going to grant defense counsel's motion, irrespective of and in spite of the defendant's personal behavior today. The court is going to grant defense counsel's motion and dismiss the matters without prejudice for failure of the witnesses to appear. We will mail a copy of the orders of dismissal for Mr. Polk's records. Have a great day and stay safe.
Thank you, Your Honor.
You're welcome. I'm ready on Arnold. This is case number 214443401, the people of the state of Michigan versus Camry Amanda Arnold. The defendant is charged with one count of operating while intoxicated, and today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. For the record, Thomasine Jefferson on behalf of Camry Arnold.
Your P number, please, Ms. Jefferson.
P42872, I'm sorry.
Ms. Arnold, your name for the record, please.
Camry Amanda Arnold.
Thank you. Today is the date set for a final pretrial conference, and the matter is scheduled at 9:10, which should denote a trial on my docket, but I don't see it in my book. Mr. Flanagan, when is this trial scheduled for?
March 11, 2024.
Oh, it's in the future. Okay. All right. March 11, 2024. All right, Ms. Jefferson, how are we proceeding?
Your Honor, at this time, the people have offered, made Ms. Arnold offer that if she pleads to driving while impaired, they'll dismiss the original charges, and she's prepared to enter that responsible plea. Thank you.
You said she's prepared to enter a responsible plea.
Well, guilty plea.
Oh, okay. Ms. Arnold, your lawyer has indicated that you want to enter a plea today. Is that what you want to do?
Yes.
Ms. Ritter, I apologize. It's so dark in that courtroom. I can't see, Ms. Ritter. The whole courtroom looked like it's dark to me, but I know y'all gonna tell me all the lights are on. Ms. Ritter, is that the people's offer for the operating while visibly impaired?
Yes, Judge, the people's offer is to reduce operating while intoxicated to operating while visibly impaired.
All right, ma'am, I am going to share my screen. On my screen, you will see an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
No, we haven't.
All right, then I am going to review them with you.
Okay.
Court will skip number 1 and go to number 2. Do you understand that you have been brought to court on a misdemeanor charge and you therefore have the following basic rights? You have the right to plead guilty, not guilty, or stand mute. If you stand mute, a plea of not guilty will be entered on your behalf. You may plead no contest with permission of the court. You have a right to a trial by jury, and you have a right to the assistance of an attorney. Do you understand those rights? Do you understand those rights?
Yes.
You have the right to an attorney appointed at public expense. Counsel, are you appointed or retained, please?
Retained, Your Honor. Thank you.
Thank you. I'll jump down to number 5. Do you understand that if you have a trial in this matter, you have the following rights: to call witnesses to speak for you at trial, to get an order signed by the court requiring witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. Should you choose to remain silent, the prosecutor would not be able to comment on your refusal to testify. You have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
Do you understand that if I accept your plea today, you will not have a trial of any kind and you will be giving up your right to a trial?
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record today to get you to enter into a plea?
No.
Are you currently on probation or parole?
No.
This is a misdemeanor. It is punishable by up to 93 days in the Wayne County Jail, up to $500 in fines plus costs. There is no mandatory minimum jail sentence. Additionally, fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment unless the court allows otherwise and for good cause shown. If you are not able to pay due to a financial hardship, you must notify the court immediately. Do you understand?
Yes.
Finally, drawing your attention to number 11 on the advice of rights form, it indicates that an appeal to the circuit court may be taken within 21 days from the date of your sentence or as permitted by law. That if you are unable to pay for an attorney, you could ask the court to appoint counsel on your behalf for the appeal. However, do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal? And if you were to change your mind about the plea, you would have to either request permission of this court to set aside the plea or request permission of the circuit court to appeal the conviction. Do you understand?
Yes.
With that understanding, do you still want to give up your rights and enter into this today?
Yes.
Ma'am, raise your right hand for me. Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. Who's going to voir dire Ms. Arnold with respect to the factual basis for the plea?
I can't judge.
Go ahead.
All right.
May I, Your Honor?
May.
Thank you. Ms. Arnold, on October 19, 2020, were you near northbound I-75 and Mack in the city of Detroit?
Yes.
And is that the county of Wayne?
Yes.
And at that time, at that location, were you operating a motor vehicle?
I was in my car, yes.
And before operating a motor vehicle, did you consume any alcohol?
Yes.
Do you recall what you consumed?
No.
What, okay, the alcohol beverage that,
Say that again.
I'm sorry, go ahead.
No, you go ahead, Miss Ritter. What was your question?
The alcohol beverage that you consumed prior to operating that motor vehicle, did it impair your ability to safely operate that motor vehicle?
Yes.
Judge, and the people stipulate to the blood alcohol content of 0.119, and with that, the people are satisfied.
Your Honor,
Satisfied?
defense was so stipulated and we're satisfied.
The court is not satisfied. In response to in response to the people's question as to whether she was operating a motor vehicle, she said, I was in my car. That's not sufficient. Was she operating the motor vehicle?
I'm sorry, Judge.
I'm sorry.
I said I wasn't driving. I wasn't driving, so.
So how am I supposed to accept a fee from a person who says she wasn't operating a motor vehicle?
Your Honor, if I may ask her a question.
You may.
Okay, Ms. Arnold, at some point prior to the officers arriving, had you been driving the vehicle? If you can recall.
Yes.
Ma'am, I need you to be still though. I'm sorry.
I'm sorry, I'm trying to get my phone charger, but yeah,
So at some point you had been driving the vehicle prior to the officers' arrival at the scene, correct?
correct.
I don't understand. I still don't understand.
The police, my
So
car
she
was
had,
parked.
you had been drinking,
Mhm.
and when you were drinking, after you were drinking, you operated the motor vehicle.
Yes,
And then at some point, the police came to a place where you was parked in the motor vehicle,
yes,
but you had been operating the motor vehicle after you had been drinking, correct?
yes.
Okay, all right, the court is satisfied. I will accept the guilty plea to one count of operating while visibly impaired. Having accepted the guilty plea, the court is going to set the matter for sentencing October 16th, if that's a good day for you, counsel.
Let me double check that date, please. It's actually not a good day. I can do the 15th or the 17th if the court has that available.
But the 15th is a Sunday, but the 17th.
Oh, I'm sorry. I'm looking at the wrong date. The wrong month, rather.
So can you do the October 16th or no?
No, Your Honor, I'm gonna be in trial.
Okay, so then what's a good day that week? What about that Friday, the 20th?
Oh, okay, I'll be here.
Okay, so then let's set the sentencing for Friday, October the 20th. Miss Arnold, you have a right to be sentenced in person or on Zoom. Which do you prefer?
Zoom is fine.
Court will set the sentencing for 9 o'clock on Zoom. Prior to sentencing, you must submit to a pre-sentence investigation and a substance abuse evaluation through the probation department. They are going to contact you by telephone. If they cannot reach you, they will mail you a letter and leave you a message directing you to contact them at a particular time. Please make sure that you respond to their phone call or their letter so that we may have a proper pre-sentence investigation on the date of your sentencing. Ms. Jefferson or Ms. Arnold, I need one of you to contact my courtroom to make sure we have the current information for Ms. Arnold, her address and phone number. Who's gonna call?
I'll call Your Honor.
And do you have my courtroom phone number or do you need it?
I think I need it, but he has called me, but yes.
All right, 965.
Okay.
2295.
Thank you. Thank you so much.
All right, you're welcome. Anything further with respect to Ms. Arnold?
No, Your Honor, that's it.
All right, then everyone have a great day. Stay safe.
You too. Thank you. Bye-bye.
Whoops. Mr. Flanagan, you may have to call Mr. Wade then.
Okay.
Mr. Allen, turn your camera back on. All right, you're a little dark, so you may have to adjust your sitting situation. However, please accept to join the breakout room. Wait for a lawyer to come in to speak with you. Join breakout room number 5, please. Number 2, I'll send you the 2. Well, it's sent him to 5. It's like it won't listen to me. I said 2. And then let me share my screen for your other client. All right, ma'am, I'm gonna send you to a breakout room. Please accept to join the breakout room and then wait for a lawyer to come in to speak with you. Oh, wait, how did I send? I didn't mean to send the person to number. That's so silly. Y'all, Zoom doing what it want to do. It won't send the people where I'm trying to send them. Okay, Mr. Allen he gonna be so tired of moving around. He's been in 3 breakout rooms. All right. Okay. All right, now, ma'am, please accept to join breakout room number 5. All right. Oh, Ms. Stevenson, did you make Mr. Murad aware of the reason we brought Mr. Al-Saidi back? He really did. She not there. She off doing something else. She not really there. Let me go in and talk to Mr. Murad. Mr. Flanagan, I'm gonna go ahead and come downstairs, okay?
Yes, ma'am. And Your Honor, I just spoke with Ms. Bumpus. She said she sent you an email on Jackson.
No, she didn't. That's not even her case. It's Miss okay. Let me look and see.
Yeah, she said on behalf of Ms. O'Driscoll.
Oh, I was getting ready to say, oh, she just did. Oh, okay.
Yep.
Oh, yeah, she like literally, okay, because y'all don't, okay. Let me send this to Ms. Stevenson. All right, I'm on my way downstairs.
Okay, I stepped outside and I'm not sure what I even stepped out there for, but I got caught up in something.
You did, and we was talking to you. You weren't there. We weren't, whatever. But I went into the breakout room on your behalf to let your colleague, Mr. Murad, know why Mr. Al-Saidi was back today.
Okay.
And now I'm on my way downstairs. Mr. Flanagan, I'm gonna make you the host while I come downstairs. Cause Ms. Ritter and Ms. Stevenson,
Is she gone too? We're both
they both
gone.
gone. They don't, so let me make Mr. Flanagan the host and I'll see y'all downstairs in a little bit.
Okay. Okay.
Green is in the building, so I just talked to him, he's coming up. Morning.
but I signed an order of dismissal for the other case. Connecting, so. All right. How many do I have on September 25th? Let's do September 25th. Anything further?
Nothing further. Thank you very much, Your Honor.
All right, ma'am, you're all set until October 25th. Have a great day. Stay safe.
Thank you, you too.
You're welcome.
October 25th.
Mr. Flanagan, can you call Mr. Docket? He's not connecting. Mr. Murat, are you ready on, Mr. Al-Said?
No, Judge, I got disconnected. Can I get my privileges back so I can wrap that one up?
I just gave him back to you.
Thank you.
All right, because I'm getting ready to start my trial.
I'll be super quick, Judge. But Your Honor, that might be a plea.
Okay, well,
I'll be quick though.
it's a bench trial, so I can interrupt myself.
Got it.
Okay. I don't know, Mr. Dox isn't connecting, so I'm gonna go ahead and start it. Oh, you don't?
Can you get it home?
Yeah,
Yeah, it says Miss Stevenson listed out.
I know, that's why I didn't know nobody's coming. All right, then let's get situated. Each defendant can come up to the table, please. And you're gonna sit behind your lawyer. So Ms. Stevenson is sitting the closest to the podium. And then. Yes, okay. So, and then let me just take a visual note. So I actually have, yes. Yes, please. So Ms. Stevenson is actually number 3, so I had 3, 1, 2. That's how they're saying. Mr. Allen.
Yes, ma'am.
So you spoke to the misdemeanor and felony defender's office this morning. However, it appears that your original lawyer has logged in. Do you have a phone number from Mr. Dox?
Yes, ma'am.
Can do me a favor, do you know how to use the chat?
I never used it, but if you let me mute him, if you let me mute myself, I'll be able to call him off a different phone. If you allow me to mute myself.
Yes, mute yourself and call him, because he's here, but he's not connecting, like he's not connected to his video or his audio, and I'm getting ready to start a trial.
Okay,
So,
ma'am.
call him and see, I'm ready.
Okay,
All right.
just give me like 30 seconds, please.
Okay, no, go ahead. All right, I'm ready on Al-Saidi. Al-Saidi, that's Al-Saidi. All right, this is case number 234467701, the people of the state of Michigan versus Hasham Ahmed Al-Saidi. Defendant is charged with 1 count of assault or assault and battery. Today is an adjourned date for a pretrial conference because I made a mistake on, I think he was here on Friday. Well, it wasn't my mistake, it was the people's mistake. Nonetheless, we made a mistake on Friday. And we dismissed 2 cases instead of 1. It should have only been a dismissal as to 1 case. Appearances, please.
For the record, Your Honor, Christina Renner on behalf of the people.
Brian Murad, PA3665, on behalf of Mr. Hisham El Saidi, who's on Zoom from the Wayne County Jail. Mr. El Saidi, state your full name for the record, sir.
Hisham Al Saidi.
All right. Thank you, sir. And please accept my apologies for misleading you last week. I know we said both cases were dismissed, but as I indicated to your lawyer this morning, the complaining witness on this case actually appeared. They had appeared, and so it was not proper for me to dismiss the case. All right, so today being the adjourned date, and I don't know if I said on the record last week, but officially the court set aside the dismissal that I said on the record last week, and I did not sign an order of dismissal for this case, but I signed an order of dismissal for the other case. Mr. Moran, how do you wish to proceed?
Your Honor, at this time, it's Mr. El Saidi's desire to tender a plea of guilty as charged in this particular matter. We're asking the court to recognize that he has been incarcerated on this matter with a parole hold. We are hoping for an immediate sentencing.
All right. Sir, have you had an opportunity to review for yourself or go over with your lawyer your constitutional rights?
Yes, ma'am.
When you went over your constitutional rights, sir, did you understand your constitutional rights?
Yes, I understood it. Yeah.
Do you understand that this is a misdemeanor and therefore you have a right to a trial? But if I accept this from you today, you are going to be giving up your right to a trial.
Yeah, I understand that.
Has anyone threatened you with anything that was not placed on the record to get you to enter into this plea?
No.
All right. And then I know from our previous contact that you are currently on parole, and in fact, you are currently being held based upon that parole hold. Is that correct?
Yes.
And do you understand that by entering into this plea, this most likely will be considered a violation of your parole?
Yes.
With that understanding, do you still want to enter into this plea today?
Yes.
All right, raise your right hand for me. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may put your down. Mr. Moran, are you on board here?
Yes, Judge. Mr. El Saidi, sir, I'm going to take you back to May 19, 2023. At that time, sir, were you in the city of Detroit and the county of Wayne?
Yes.
On that same date, sir, did you come into contact with a one Mr. William Estes?
Yes.
And did you strike Mr. Estes?
Yes.
Did you have permission by Mr. Estes to strike Mr. Estes?
No.
Your Honor, defense is satisfied.
Satisfied. Court is satisfied. I would accept a guilty plea of 1 count of assault or assault battery. Mr. Murad, I know you want immediate sentencing. Unfortunately, due to the victim's right to make a statement, I cannot impose immediate sentencing. But what I will do, Ms. Ritter, do you have contact information for that? This is the victim that showed up.
I do, yeah.
I will try to do a quick turnaround for a Zoom sentencing on Wednesday and give Ms. Ritter an opportunity to contact the victim and see if they want to make a victim impact statement, but I have to allow for the victim to make a victim's impact statement.
Wednesday, what?
Mr. Moran, he'll explain it to you. I said I can't sentence you right now because the victim has a right to come in and make a statement, but I'll send you back to the breakout room. Mr. Moran, if you could explain that to him, but I'll bring him back Wednesday. I'll let the prosecutor contact the witness and see if they want to make a statement.
Thank you, Your Honor. And that's the 13th of this month, correct?
Yes, 13.
Thank you very much, Judge. I'll explain it to Mr. El-Saidi in breakout room.
Okay, I'll send them back.
Thank you.
All right. All right. I'll put that on for Wednesday. Yeah. Mr. Dox?
Good morning, this is Mr. Doc's assistant, and he's coming right now. He's in the other courtroom. He's coming out.
It's only one person can let the assistant check in for him. That's Daniel. Yeah, P number P2 something.
Good morning, Your Honor.
Mr. Dox, P number 2 close to mine for him to be talking about his assistant checking in. Good morning, Mr. Dox.
Good morning.
I'm ready on Allen. We thought your representation had ended. So please accept my apology. I sent your client in to speak with the defender's office. So he did speak with the defender's office this morning, but please accept my apology for that. This is case number 215615901, the People versus Kenyatta Jawan. Allen, defendant, is charged with 1 count of weapons purchasing without a license. Today is the date set for review. Mr. Dox, your appearance, please.
Good morning, Your Honor and Honorable Staff. Attorney Quentin Dox, P number 79657, on behalf of Mr. Allen. Mr. Allen, please state your full name for the record.
Kenyatta Jawan Allen.
All right. Somebody gave me a paper. Y'all know I will lose paper. I will lose paper. Did I give it back to you by mistake?
Yeah.
Oh, okay, thank you. All right, today's the day set for review, and I have an update from Ms. Bumpus. Stating that I placed Mr. Allen on a 9-month probation, and I did that back in 2022, but on May 16th, I extended his probation to November. He has completed 3 sessions of anger management, and he still owes $400 on this case and $2,100 in total to 36 District Court. Do you want to just continue him to his final review date and see?
Yes, Your Honor, please.
Okay. All right, and then we'll switch it back to Mr. Dox. All right. All right, so let's get it done, Mr. Allen, okay?
Yes, ma'am.
All right, so I'm gonna continue you to November 16th at 10 o'clock p.m. And then let's finish that anger management. You need to, if you can't pay the total that you owe to 36 District Court, you need to sign up for the payment plan, okay?
Okay, and how do I do that, Your Honor?
Talk to your probation officer. They'll help you sign up for the payment plan.
Okay.
All right.
Thank you, Mr. Allen. You're all set. Well, if you have any questions, call me, Mr. Allen.
Okay, thank you.
All right, good to see you, Mr. Dox. Have a great day. Stay safe.
Good seeing you too, Your Honor. Stay safe.
All right, thank you. All right. Okay, who is this? Tell the lawyers I'm ready.
Lawyers, the judge is ready.
They're supposed to be here, but I'm not gonna be able to do them. Mr. Murad?
Yes, Your Honor.
Do you see the person that's in the waiting room? Don't call their name. It's a HIDTA case. Do you see them? Do you all have a phone number for that person? Ms. Stevenson?
I don't have it with me, Judge.
Well, let's rename the person. I'm gonna rename them, bring them in, and then you talk to them in the waiting room, but I can't do, I'm getting ready to start my trial, okay? Did we get a report on that person?
I didn't see that one.
So Judge, we're just getting him a new date?
Yeah, give them a, let's give them a new date. Let me see if I got a report. I did. Oh, it's good. He doesn't have any remaining conditions, and he is I think it's his discharge date. He's gonna be discharged.
Judge, can we just waive his appearance and I can send him out?
Yeah, well, I'm gonna just discharge him, but, let's let him know what's going on.
Will do.
I'll bring him in the break, I'll bring him in, and then you can, just tell him what's going on, okay?
Did you send it to me and I over?
I don't know.
Oh, okay.
No.
All right.
I did forward it to you. But, I forwarded it to you Friday at 1:59 p.m. I was working early, I was getting it done early. The person I just let in the breakout room, in the courtroom, please accept to join the breakout room. All right, they're discharged, Mr. Moran. Okay, then I'm ready. Turn the camera away from me. All right, this is case number B. This is case number. And then zoom it out like I guess. This is case number 184543303, the people of the state of Michigan. Strike that, 3301, the people of the state of Michigan versus Keith Wayne Ditmore. 02, the people of the state of Michigan versus Corey Devon Spencer. And 03, people of the state of Michigan versus Eric William Abramski. The defendants are each charged with 1 count of assault aggravated, and as to each defendant, today is the date set for waiver trial. Appearance, please, on behalf of Mr. Ditmore.
Roger Free on behalf of Mr. Wayne Keith Ditmore,
And your P number.
P62269.
And Mr. Ditmore, your name.
Keith Wayne Ditmore Jr.
Thank you. On behalf of Mr. Spencer.
Your Honor, Jeffrey Sherbo, P25324, on behalf of Mr. Spencer, without an assistant calling it.
He was trying to let me know, Judge, I'm P2 too, so I'm gonna get away with some stuff during this trial. We're gonna see.
Well, just the last guy.
I know, with a P79. Mr. Ditmore, please state your name, sir.
Mr. Spencer.
I'm sorry, Mr. Spencer, yes.
Corey Devon Spencer.
Thank you. And on behalf of Mr. Abramski.
For the record, Your Honor, Janice Stevens, P57708, appearing on behalf of Mr. Derek Abramski. Mr. Abramski, please tell Judge Bryant your full name.
Derek William Abramski.
All right, today is the date set for waiver trial. With respect to the trial, are there any preliminary issues before we begin? Gentlemen, you may be seated.
Judge, I didn't know.
Oh, you did?
Yeah.
Oh, you're right, I did. Isn't that something? And I'm a stickler for the people going first. You mean I let all 3 of these people put their appearance on? Ms. Ritter, don't take it as anything other than, I don't know what to take it as. Ms. Ritter, your appearance, please.
Thank you, Your Honor. Good morning, Christina Ritter on behalf of the people, P number 83505. Your Honor, I also have my officer in charge, President of the courtroom, who's standing up to my right.
Morning, Your Honor. Secretary Derek Mason.
Thank you. All right. Again, I apologize, Ms. Ritter. Are there any preliminary matters before we begin?
Just a couple on behalf of the people. Judge. One, people did file an amended complaint with the court, adding the lesser included offense of count 2, assault and battery. I did give notice and copy of those complaints.
And I do see it now on my desk. Any response from any defendant with respect to the amended complaint?
Your Honor, on behalf of Mr. Spencer, and for the purpose of the reporter, should I indicate my name each time or?
No.
Okay. I just find it absolutely incredible that we've been here for 5 years and we get this today. I understand that it may in fact be a lesser included offense, but we had 1 charge and that's what we've been coming for. You've had final pretrial conferences, and to amend it on the day of trial, I think would be improper.
Anyone else?
I would agree, Your Honor, on behalf of Mr. Ditmore, Your Honor. Just added that when it said 5 years, it's over 5 years, Judge, since it happened. And we've had numerous court appearances, appeals on certain issues. And it's just another example them trying to harass and intimidate the defense judge to add this charge now, we would raise our objections for the record.
And anything on behalf of Mr. Brown?
And for the record, Your Honor, I do understand that people have, this is not, it's not untimely according to the court rules, Your Honor, but I would concur with Brothers Counsel that we've been at this for a number of years at this point. And I do, I have the highest regard for Ms. Ritter and the way she practices law, Your Honor, but we do believe it's a little bit, the ninth hour to come with an amended charge, even if it is the lesser included offense, Your Honor. We take it as a surprise, but I do understand it's not outside of anything that the court will permit her.
All right, the court is going to allow the amendment as the court rules to indicate that people have a right to amend the charges up to, through, and including trial. When the court allows the amendment. Anything further?
Yes, Judge. In addition, Your Honor, I did speak with Sister and Brothers Counsels regarding the photos of the injuries sustained by the complainant witness, and they all have stipulated to the photo.
On behalf of, just say it on in the order that you begin, because this is 3-1-2.
Okay.
3-1-2.
On behalf of Mr. Bramsky, Your Honor, having had the opportunity to confirm with people with regard to the photographs of the alleged injuries, Your Honor, at this point, we are going to stipulate.
On behalf of Mr. Ditmore.
We would stipulate, Your Honor, would ask the court just to let us cross-examine before we admit it in at that
Absolutely.
time.
And then on behalf of Mr.
I would have no, Spencer, Your Honor, I would have no objection to that procedure. I assume it's the photos that have been previously provided.
Absolutely, and she'll show you before she
Right.
presents it.
And with Mr. Farina's proviso, absolutely no problem.
All right. Anything further?
One last thing, Judge. So during final pretrial conferences, there was a stipulation by people for the medical records that were, I guess, obtained by the complainant witness on the day of the incident. And the people did stipulate to the copy that was provided in the summary. However, Mr. Sherbo just showed me another version of the medical records that the people stipulated to. People are not stipulating to the version of Mr. Sherbo has provided, but that's not the same as what's in the summary.
And is that something that's gonna come up now or in the defense case?
Well, it's going to come up, Your Honor. First of all, I don't disagree that this isn't a different set. This is the full set that was subpoenaed in the civil case from, the certification to the end. The records that were provided in discovery, assuming they're the records we have, they do have the pages of interest to us, which would be pages 20 and 21 on the documents I gave Ms. Ritter today. If you look to confirm, those are the pages that show that there was a blood alcohol content of 0.245. And that's really the only page. The rest is superfluous, so I can't say that.
So, I mean, this is the way I'll handle it. I don't know how it's gonna come into play. If there's something in the record that the people have not stipulated to, that is being presented to the court, then I'll address it at that time. So the record that you stipulated to, Mr. Sherbo says, is included in the record that he gave you, which it sounds like you're saying the record that you gave her is a complete record. And the other part that you stipulated to was partial of that complete record.
As I understand it, yes, Your Honor. Again, and I can't find my copy of this record today, pages 20, really page 20 is the only page we need, because it says on the bottom ethanol serum 0.242, and that's the emergency documentation. I believe that was in the stuff that we got from the prosecutor's office. Really, I just wanted a complete copy, but page 20 is the only one.
I have 4 pages that you're talking about included in that they did give to us, Judge, which has the 0.242 alcohol ethanol.
All I'm saying is, and I'm not saying that the other pages are not admissible. What I'm saying is, as it relates to the people's stipulation, I will receive pages that she stipulated to. If there are any other pages, she can consider stipulating to them, and if not, depending on how they're being presented, you may have to bring in the keeper of the record. Ms. Nicholson?
On behalf of Mr. Branson, before the court just rules on it, can I just have a quick conference with Ms. Rick?
Sure.
I want to make sure that.
Right, that's why.
That's why you came down.
That's why I came upstairs.
Okay.
Yeah. I mean, I pushed it because I can't move it. I thought I did it. But it was down. That's why I walked, instead of walking all the way down to the.
Down for a few days last week too.
Okay.
That's the date, so it's.
Great.
All right, anything further?
Not from us, Your Honor.
Nothing on behalf of Mr. Branson.
One last thing, Judge, I'm not hoping I plan on using one of the photos, so I don't know how to.
They said they stipulated.
Oh, okay.
But you know, I don't need to see, I might not need to see it in the opening, but if you, well, let's just go with it. There are many witnesses, nobody asked me for sequestration.
I'm standing up for it.
Oh, okay,
Look for sequestration witnesses, right?
all right, and, Ms. Ritter, are you requesting an exception?
Yes, Your Honor, with the exception of my officer in charge, who is present, for Detective Mason, who is the officer in charge on the original cases.
Right, and he the reason why I adjourned my trial that I wasn't happy with, your OIC, but we're here. Okay, we're here and we're ready to proceed,
I'm trying to
okay?
see if I have an objection to that.
You can place it on the record, but I'm gonna overrule it.
All right, well, never mind.
All right, the motion for sequestration is granted. And the people's request for the, exceptions for the OIC is also granted. So, if there's anyone in the room that will testify today or in the future on behalf of the people or on behalf of the defense, with the exception of the officer in charge, you must leave the courtroom. Additionally, everyone is prohibited from, so I am live streaming the trial. And everyone is prohibited from watching this trial on YouTube. I am going to question every witness that takes this witness stand under oath as to whether they have viewed any portion of these proceedings on YouTube, okay? Anything further?
Yes, Judge, one other.
Oh, yes.
We have a witness, Ms. Paris Floyd, that's out in the hallway, was subpoenaed by the prosecution. But she can't testify Wednesday when you kind of our case, but can we have her testify tomorrow afternoon? She's out of town, that's her job. She's here and she can testify.
Mr. Farina, can I ask you one favor?
Yes, Judge.
I might ask you another one, but right now.
Yes.
The plexiglass is still real and I can barely hear you.
But what I was saying, Your Honor, is that Ms. Floyd, who's a witness called by prosecution and used by us as well, is in the hallway. She was subpoenaed for this morning, but we'll need her for Wednesday. Sorry, she can't testify Wednesday. We probably need her for tomorrow afternoon, so we'll have her come back tomorrow afternoon.
Do you think, is that someone you're using?
Judge, the people who just subpoena the intended witnesses.
Oh, okay.
And to provide them for some people.
Oh, that's a police officer or something?
No, she was an eyewitness at this.
Oh, okay, but she won't be needed until
Right,
tomorrow.
Yeah.
She can be released, the people, now, I don't want dead space though. But, okay, she can be released and told to come back tomorrow, you saying afternoon?
Afternoon, say 2 o'clock, that'd be,
Sure.
okay, I'll let her know, Judge.
Okay.
And also, Your Honor, tomorrow we have an expert coming, and if I would ask the court to allow him to testify out of order if the prosecutor's not ready, he's available from 9 to 11 or at least in the morning tomorrow. and we're having them come in that I've identified to Ms. Ritter. So if we're not through her case today, whether that would be a problem based on his availability. His name is Kenneth Bora. And also, Your Honor, there is another person in the courtroom. His name is Michael Sherbo, who's P74882.
He's not getting an assistant. That's your assistant, right?
I'm trying to keep him off the streets. But here's my son, Michael, and he returned from Charleston, is now working. So
Okay, awesome. And then, do we know who the young lady is in the back of the courtroom?
Yes, ma'am. Support.
that is
And,
a mom.
Okay,
Mom from Mr. Dick.
okay, she will not be testifying.
No.
Okay, all right. With respect to calling the expert out of order, I guess if we go ahead and get started, Ms. Ritter might be able to get finished. Okay.
I'll let my witness.
Yes, let your witness know, and while you're doing that, the people may, oh, no, it's open and statement first. All right, will the people be making an opening statement? All right, you're all set, Mr. Farina?
Yes, Your Honor, she'll be back at 2:00 tomorrow.
Okay, thank you. All right, I think we've covered all the preliminaries. The people may begin your opening statement.
Thank you, Your Honor. Your Honor, on April 20th of 2018, the complaint witness Christopher Floyd headed downtown to meet up with a couple college friends. The plan was to go out, have a couple of drinks, have a good time with his friends downtown. And eventually, Mr. Floyd and a couple of these friends ended up at the Coliseum bar located on 8 Mile in the city of Detroit. Now, Mr. Floyd and a couple of his friends arrived at this bar about 9 o'clock that night on April 20th of 2018. And you'll hear testimony, Your Honor, from the complainant witness, Mr. Christopher Floyd, as to how he went into the bar, him and his friends were in a booth. He was there for about 40 minutes to an hour, and then he released himself to go to the restroom. Now, Your Honor, there is no testimony from the complainant witness that when he comes out of the restroom, that's when he comes in contact with the 3 defendants that are in court today, Your Honor. Mr. Floyd testified that when he came out of the restroom, he came in contact with Mr. Corey Spencer and another individual who grabbed him by his arms to restrain him. He'll testify that Mr. Ditmore approached him and began punching him continuously in his face. And he'll also testify that Mr. Obransky soon approached and again was punching him continuously in his face. Your Honor, the people have been dealing with this case since 2018, which brings us to about 5.5 years now. I want the court to pay attention to the testimony given by the complainant witness today. And that's important, Your Honor, because like I said, 5.5 years, we're still in court trying to figure out what happened to Mr. Floyd that night at the Coliseum Park. And Your Honor, the people kind of compared this case to a puzzle with one missing piece. And that missing piece, Your Honor, hopefully the people tend to prove to this court that on that day, Mr. Floyd came into contact with 3 defendants and they assaulted Mr. Floyd continuously outside of the restroom at this bar. You'll hear testimony, Your Honor, from Mr. Floyd that he was punched in his face several times by Mr. Ditmore and Mr. Obransky, that it caused his eye to swell and blood running down his face during the time of this assault. Your Honor, the people tend to call Detective Mason as well, who was the officer in charge of this case, and he'll testify to the court as to his role in this case. Like I said, Detective Mason has been on this case since 2018, so he'll explain to the court how we come to this court today with these 3 defendants sitting in the court. Now, Your Honor, the issue that arises from this case comes from identification and intoxication. Now, those 2 issues will be presented by defense counsel, and they'll tell the court that Mr. Floyd was so intoxicated that he couldn't identify any of the parties. That Mr. Floyd mistakenly identified one of the defendants and therefore he misidentified the other defendants. But I want the court again to pay attention to the testimony that will come through from the complaining witness, who will give a detailed account of what happened on that day in the Coliseum Bar, and Detective Mason, who will walk the court through the process and how the lineups were conducted in order to get these defendants identified in court today. Your Honor, the people also tends to bring in a video interview from a statement made by Mr. Didmore. And Mr. Didmore actually comes into the police precinct voluntarily and makes a statement to Detective Mason. So, Your Honor, once the court hears the testimony from the witnesses, once the court sees the photos that people tend to bring through as exhibits to corroborate the events that Mr. Floyd will testify to, and once the court hears the testimony from Detective Mason, the people hope that the court can put that last piece of the puzzle into this picture as to why these three defendants are here in court today. And once the court takes all of that evidence into consideration provided by the people wants this court to find Mr. Didmore, Mr. Spencer, Mr. Brent guilty of count 1, aggravated assault, or in the alternative, the lesser included offense, assault or assault battery. Thank you.
Any opening statement at this time on behalf of Mr. Didmore?
May we go out of order, Your Honor, and I'll go first?
You may.
Your Honor, again, for the record, Jeffrey Sherbill on behalf of the defendant Corey Spencer. Your Honor, I feel like I just went to a library and went to the fiction column. The facts are so different that will be established before this court that this court could find nothing but reasonable doubt. What's interesting in the testimony will show that Mr. Floyd, the complaining witness in this matter, I don't want to call him the victim, but the complaining witness, blew at 12:36 at night through blood serum of 0.24. Tomorrow, Dr. Kenneth Bora is going to be here and will testify that based on what the real testimony will be from Mr. Floyd, because clearly 5 years later, we can't remember what he said 5 years ago, because 5 years ago, he said he got there at 9 o'clock. That 5 years back, so that 5 hours back from, 3.5 hours back from 12:36 to 9 o'clock, we'll take that 0.24 to a 0.32 to a 0.35 at the time of the alleged incident. What my esteemed colleague fails to tell you that the testimony will not support, other than Mr. Floyd's unsubstantiated testimony, that he walked out of the bathroom and he got jumped for no reason whatsoever. What the testimony will show is that Mr. Floyd was in a drunken, out of his mind condition, takes a young lady into one of those back rooms that I've never seen in my life, Your Honor, and then grabs another lady, Miss Paris Floyd, not related, goes into the back room, and the testimony will say, quote unquote, he was just a drunken fool. There's an issue in the back room. Mr. Floyd comes out. He is so intoxicated, he goes after one of the bouncers, ends up being restrained, not by Mr. Spencer, falls to the ground and hits his head on a table in a wall. Then you're going to hear so many inconsistencies in terms of reasonable doubt, but some of those that are really key. There was no identification that night. There was somebody on behalf of Mr. Floyd goes into the bar, takes pictures. There's ruse performed by the detectives in this case by getting their cabaret licenses and trying to create a photo array. During the photo array, 3 people are picked out of the photo arrays. 2 of them were employees, but not there that night. And the testimony will show Mr. Faison, who's already been dismissed. Mr. Abramsky wasn't even there that night. And then there's some guy whose picture nobody knows, a guy named Michael Sullivan. His picture circled with Floyd. So within a month, there are 3 different photo arrays, 3 wrongly identified people by Mr. Floyd. What's so significant to that is when Mr. Floyd is interviewed by the police, might have been Mr. Detective Mason, he says, I came out of the bathroom, a brother grabbed me who had dreadlocks like the Predator. That's what his testimony is going to be. I'm assuming that's what it's going to show. And then he says, so there's a guy with dreadlocks, he says, can't identify. And then somebody else grabbed me from the right, but I don't know who it was. And then some white guys came at me from the front. That's what his testimony is. So for the first 72 hours, he doesn't know who it is until there's these created photo arrays. There's no testimony that the complaining witness can identify anybody. That coincides with the executive functioning deficits that he has when he blows a .35 that Dr. Borer will testify to. So during the course of the trial, we're going to, obviously, we have impeachment available testimony for Mr. Floyd because we have sworn statements that he's taken that will be used. There's going to be the evidence of my client. There will be the evidence of the other defendants. We've got 2 guys that weren't even there who are going to testify. So we asked the court, remembering that this is still a reasonable doubt standard, that there is no way that there can be anything but reasonable doubt when you hear the testimony. Thank you.
All right. Any opening statement on behalf of Mr. Bigmore?
Yes, Your Honor. If I may proceed, Judge. Your Honor, my co-counsel's characterization of this as fantasy would be more accurate. It's not an issue of simple identification and intoxication. When Mr. Floyd started drinking at 6 o'clock by himself, before at Flood's bar, then he goes again drinking at Greektown, then he goes to the club. Yes, his alcohol level at 4 hours after the incident is 0.24. Yes, I get that. What happens in this case, though, Judge, is that leads to a fantasy and focusing on reasonable doubt. When you show up and you say that a predator grabs you from behind the neck with dreadlocks, 2 bouncers grab each arm who don't necessarily know much about each other, have formed no mens rea to attack you. You have no argument with them. You come out of the bathroom, one's holding an arm, one's holding another arm, one's holding you in the neck, one stands in front of you, 2 stand in front of you, the white men stand in front of you, the black men hold your arms, and then they start punching. No reason. It makes no sense. These are people who are employed to keep security, to keep the peace. There's no history of aggression between them and the complaining witness. It makes no sense. It's bizarre. The dancer will testify she was there. She was 1 or 2 that he brought to the back, didn't pay, threw the money, but not enough, and caused a disturbance. He then pushes past one of the bouncers and takes a swing at another one. He's then restrained. He is big, and he starts fighting. He created the situation that led to his injuries. He was the aggressor. He put himself in that position by consuming. That's where the intoxication comes into place, and other issues as well, such that he can't even create a plausible version of what happened. That's what we're dealing with, Judge. And if he was injured, and when he was injured, that's his cause, his fault. He's the aggressor. And that's why we're here today. But you know what's interesting also, Judge, and I want to finish up by saying this. 5 years 5 years of fighting this. My client's gone through hell defending himself and finding the money to try and survive and make this thing work. It's affected all of their lives. All my client and all the people did was to do their job. They don't get paid by fighting people. They don't have protection of the club. There's no motive. There's no mens rea.
Well, what's going to happen is we're going to listen to the rest of this tomorrow, and then some more Judge Bryant tomorrow. We already hit the 2-hour mark on the channel. Don't forget, you guys, if you're not subscribed to the new channel, please go over and make sure you're subscribed to that new channel, because Monday we're going live on the new channel. Monday we'll be going live on the new channel, and from there on in, I will be live on that new channel. And then removing some of the court stuff is going to be still left on this channel because it obviously had views to it. So I'm leaving that content on this old channel, but I'm putting the stuff over onto the new channel. Whether or not that new channel makes it or not, it doesn't matter to me. I'm just doing it because I feel confident when I come and do a live stream that I'm not going to be attacked. I can do a live stream and don't have the stress. Anyway, talking about court stuff, I thought about this for a while. And putting court stuff on a tech channel maybe might not be a good idea because the numbers have been so bad lately. So I figured I'd just create a new channel with the court stuff and I'll just go from there. Leave this channel as a tech channel. Yes, Trin. Yes. Yes, we sure will be. I think next weekend is going to be, what Christmas is Thursday? Let's see. So Christmas is Thursday, and I'm not going to stream. I'm not streaming on Thursday the 25th because it's Christmas Day. But as far as swapping content over to the new channel, that I am going to be doing. I'm going to be doing that within the next couple of days. Yes, next weekend, starting Monday, we'll be on the new channel. Yeah, I just figured that, I mean, it's like I said, I was looking at the numbers, and numbers weren't all that great. And you got a tech channel talking about court stuff, and it was a good idea at the beginning, but now yeah, I like that name. Daniel's Court Corner. I like that name. And that's also the email address. The email address is danielscourtcorner@gmail.com. And that was a pain in the ass to do. Why is that banner not flying? Oh, I didn't do the banner thing. Oh, that's all right. I'll remember to do it the next time. Well, that's it, ladies and gentlemen. Maybe the two fleas need to come on here and watch Nobody's been attacking the channel. It's just the fact that this channel got attacked and they ruined the name of this channel. I got the blame for it. Yeah, I think that's why I decided that I got into something that I liked, and I said, okay, well, I'm going to transfer this over to a new channel, and this time I'm sticking by it. Whether the channel grows or not, I don't care. I think the name will probably get, like you said, will get caught into the algorithm. Nobody attacked this channel, but I know that a certain group attacked two creators that I have respect for. So that'll be it for today. I will see you guys tomorrow. Tata and ciao ciao, and we will continue this tomorrow. I hope to see you. I hope to see you there. All right, everybody. I'm out.